In 1971, the U.S. Supreme Court declared the death penalty in the United States unconstitutional in a case called Furman versus Georgia. And at that time, everybody that was on death row in the United States had their sentence reduced to life. The Florida legislature was the first legislature to reenact the death penalty, and they did that in 1972. Unfortunately, the Florida legislature didn't get it right. In fact, they've never gotten it right, and it's been declared unconstitutional at least 2 times in the last, well, year and a half. But the legislature has reenacted the death penalty now, and the way it works currently in Florida is the prosecutor has the responsibility to decide if the death penalty is going to be an issue in the case. And it has to do with the evidence in the case. If there are certain aggravating circumstances to a first-degree murder, then the prosecutor can seek the death penalty. Doesn't have to, but can. For instance, if the killing is cold, calculated, and premeditated, like an assassination, that's an aggravating circumstance. If it's heinous, atrocious, and cruel, a torture murder, then that can be an aggravating circumstance. If it was for pecuniary gain, that can be an aggravating circumstance. So there's a whole laundry list of those things, and if any of them are applicable, then the prosecutor has the authority to decide yes or no in seeking the death penalty. Once the person is tried and found guilty of first-degree murder, a second hearing is held before the same jury. And now, under the current law, that jury would have to unanimously make a recommendation that the death penalty be imposed before it could be imposed. If the jury doesn't do that, or doesn't come up with 12 votes one way or the other, then a life sentence has to be imposed. Life in Florida means exactly that. In fact, a lot of people say that a death sentence and a life sentence in Florida are the same. You die in prison. It's just a question of when.
Under Florida law, is a state attorney forced to seek the death penalty against an accused killer?
No, absolutely not. The state attorney has the discretion and the duty to evaluate the case, the facts of the case, not the politics, and to determine of those facts what they really in good faith think and believe in good faith that they can prove. And then they make that decision. They are not required to seek the death penalty ever. And I've been hearing some of these things lately, but I can tell you now, I am currently defending 2 first-degree murder cases in which the death penalty was waived by the current state attorney's predecessor. And so it's always done. I think they waive the death penalty, in my experience, far more often than they seek it.